All right, I'm going to call the docket. When I call the docket, you need to let me know that you are here. Otherwise, I'm going to, counsel, instead of the 16th, actually, let's put it on the 15th. Because I don't know how long your motion to suppress will go.
Okay.
Andrew, instead of the 16th, it's going to be the 15th. Thank you. All right, I'm going to call the docket. When I call the docket, you need to stand and let me know you're here. Otherwise, I'm going to assume you're not here and a warrant may be issued for your arrest. There's to be no sitting on the front row. Edward Ramirez. Edward Ramirez. Luis Mora, custody, Arturo Villanueva. Thank you. Byron AG or Age. I think that may have been reset. I'm going to look and see about that. Tua Hong, custody, Jose Escalin. Jose Ivan Escalin. Eduardo Porter.
He's present, Judge.
Thank you. Dominique Camacho.
Here. Council's present, Judge.
Charles Claycomb. Charles A. Claycomb. Alexis Emiliano Gonzalez. Christy Brown is being recalled for January 15th for a motion to suppress. Tyrell Benjamin. Lance, look like we have a problem.
Or DC Day.
Yeah, that's true. Jesse Marino. Adalia Sobbs, custody. Troy Mishler.
Present with counsel. Good morning, Your Honor.
Good morning. Tony Medellin. Tony Salinas Medellin. Eric Padilla, custody. Sandra Gaitan. Gary Flower. Gary Joe Flower Jr. Jennifer Rodriguez, custody. Luis Briceño. Javier Herrera, custody. Joshua Johnson, he's on Zoom. Edgar Aguilar, custody. William Camarillo. Mackay Williams, custody. Jared Sanchez. Where?
No.
Francisco Galza Martinez. Joshua Pardo. Eduardo Ramon, custody. Theodore McCullough. Rogelio Valaro, custody. Kevin Perel, that has been reset. Corey Puente, custody. Anyone whose name was not called or you came in late. All right, everyone, these are the rules. You need to follow these rules because I'm cutting off the docket today at 11 a.m. because we have a motion to suppress in a jury trial. If you are ready to proceed, you can approach the court. What do I mean by ready to proceed? You confer with your client, you confer with the state. Once you've done those things, just ask the clerk to pull your file and you can have a seat. I'm going to call you in the order of appearance. If you have a client who's in custody, yes, they need to be brought out and yes, you need to confer with them. All right, everyone, move with the purpose, move with the plan. And there's supposed to be a plea online, but I haven't received any paperwork.
Okay, I'll check with the.
All right. Counsel?
Good morning, Your Honor.
All right, let me see, because I'm not hearing you.
Better?
All right, there may be something wrong with our audio because I don't hear you. Are you able to hear us? If you can give me a thumbs up.
I can hear you.
Okay, what I'm going to do, is your client Alexis?
No, my client is Joshua Johnson. He said he's on.
If you could use chat for me until we have our audio worked out on this end, please.
Yeah. My client is Joshua Johnson. He says that he's on the Zoom currently. I don't know if you see him. I don't know who Alexis is. I'll play some Christmas music because I don't know what else to say.
But you're not muted at all.
No. And so I'm trying to see. And the volume is up on this end. They came down here today to fix something.
No problem.
Let me see if I can get them to come back. In telemix room, echo microphone, famous system, echo counseling speaker phone and speakers, Testron, famous speaker. Okay, thanks. I'm sorry. Okay, bye-bye. All right, just give us a moment. We're gonna have tech come over to see what's going on with our microphones on this end.
Okay.
And I'm gonna put a message in the chat.
Okay.
Morning.
This one right here. I'm not using this. Oh, okay.
See the file on Byron AG, please. And also on Christy Brown.
I gave you Chrissy Ranger.
All right, thank you. All right, there we go. Edward Ramirez. Byron Ag, Jose Escalin, Charles Claycomb, Alexis Gonzalez, Tyrell Benjamin, Tony Medellin, Gary Joe Flower. Bud, that's your client. All right, is he? All right, thank you.
Francisco Martinez.
Hi, thank you so much. So, I cannot hear him. Joseph,
His mic is muted.
can you unmute? Oh, it wasn't muted. Can you
Yes,
say
Your Honor.
something for us?
Can you hear me? Test, test, test. Can you hear me now?
Could you say something now?
Yeah, I'm still saying something. Can you hear me now?
Yes, thank you.
All right, perfect. My client, just while I'm here, the client says that he's on and watching live. I don't know how, but
Is his name Alexis?
no, it's Joshua Johnson. So I don't know who Lex is. I asked him if that's what his screen name is. He said no.
All right.
There he is.
All right, Joshua, you'll need to start your video. All right, and counsel, have you all received paperwork and completed paperwork?
Yes, the paperwork was sent over to us this morning. Mr. Johnson signed it online and then I cannot open it, but I went over the plea agreement with Mr. Johnson. I went over his constitutional rights and all that prior to getting on the Zoom.
All right, because it hasn't come to me, so just give me a moment. I'm gonna put you in a breakout room, okay?
Okay, we'll be patient.
Thank you. And Lance, are you able to check to see where the paperwork is?
We know who the prosecutor is on.
Who's the prosecutor on Vanderbilt's case? His client name is Joshua.
I am, Your Honor.
All right.
Do you know where the paperwork is in the process? Did you send it via?
I don't know what paperwork he's talking about because I'm working on mine right now.
All righty. There we go.
HLER.
Hello.
Judge, can we approach?
Sure.
It's on Mishler, it's a first setting, judge. For the defense, there's a question of, there's some discovery that's maintained.
Okay, where's your client?
He's here.
Right, he needs to come up. No problem.
Which side would you like him on, Judge?
Oh, you're there and he's in the center.
Thank you.
Sure, no problem. All right, so what is the issue?
So there is evidence that's maintained on a flash drive that contains material that cannot be copied.
Okay.
I need to verify if the material he's asking about is something I can pull off and upload, or if he just needs to come in and look at it. And I believe he needs to review the flash drive or have an investigator.
All right. Lance, can you give me a date at the end of January? And it'll be for discovery and it's on Troy Mishler.
On the same day on Thursday, Judge,
Yes, we can put it on a Thursday.
30th.
All right. January 30th. They'll give you a reset form. Once you sign the reset form, you'll be excused, and make sure you put your email address on it so they can send you notices in case something happens with Odyssey.
Absolutely, Judge. Thank you.
All right, thank you. Thank you for dressing appropriately for court. Thank you.
Great. Yeah.
That's what Mr. Esplin, I guess he didn't show up. Yeah, I'm not gonna go. I'll see him. Notice on the case that. Okay. Yes. Thank you.
Okay.
Can I see the file on Kevin Carell? Yes. I just need to put the date in here. Jason, did you all come to an agreement on a date on Curiel?
Sorry.
Did you all come to an agreement? I know you all agreed to reset the sentencing. Did you all come to agreement on a specific date? It's Kevin, Curiel.
Oh, no. I didn't, I never got a chance to talk to them, but I thought.
Oh, no, this is the one where you,
I know it was so.
mhm. Still trapped mind.
It's just, it just won't come out.
Yeah. All right, thank you.
Now we serve all these people. Yeah. Hector, Garza. Hector, fire. Paperwork, would you be able to look up a different one for me that's not up to date back? Yeah, I wanted to tell you something. Would you have a second to look up a case? 24 PF 12597. It's indicted now. The question is, when can I break a rule? How do we have? Well, let's push that baby out. Let's work out something. I'm off the next 2 weeks, but first week in January, second week in January, something like that. I think January 14th is good. Let me just double check. January 14 looks like a nice quiet day. It what? BB's a misdemeanor? The felonies dismissed, all she has the misdemeanor?
Misdemeanor.
Oh, okay, yeah,
CF number came out.
yeah,
Yes, felony misdemeanor.
yeah, in here. I think it's in here.
Okay,
Yeah, 114.
got it.
Okay. Oh, let me grab the indicted case number.
Before CR 1011569.
1011569.
No, 0
Yeah, yeah.
11569.
0 11569. This new system we all.
Edward Martin, Ramirez. Yeah, you Edward? Yeah.
Put 930. He was-
What, A, Brian? H. Jose. Ivan. Escuela. Bacon, Charles. Lex Gonzalez. Rio, Antonio Benjamin. Edwin Tony. Gary Flower.
Thank you.
Oh.
Edward Ramirez.
So just compliance hearing.
All right. Yes.
Judge, a supplemental report was sent into the court to notify the court
Everyone, please whisper.
of the terms that Mr. Ramirez has satisfied, as well as the inability to afford completing 2 of the classes, which is the theft course level 1 and the theft program level 2. After going through his financials and doing a financial assessment, it does appear that he's just simply unable to afford the classes. The case expires, he was granted 2 years and he was extended for 1 year and 6 months. We don't know that he will be able to even in the future afford these.
All right. Is
classes.
he able to, are you able to afford $25?
No, ma'am, because my check is only nine 43, and then plus my rent and my bills, my phone. And I've been giving money to the probation office every month.
All right. So how much do you pay how much do you pay probation office every month?
Dollars, ma'am.
All right. So 1 month, if he's saying he's paying probation $40 a month, 1 month, can he not pay probation and pay $25 for a course online?
That's fine with me, Judge.
All right. So 1 month, you don't pay probation. If you're able to go online, I just looked it up. There's a theft course online that's $25. And let me just tell you, usually I will give people my theft course. And you know what my theft course is? Don't steal.
Yes, ma'am. Well,
But here's the problem. The reason why I'm not giving you my theft course is because you're here for a theft that's enhanced, which means that you've stolen before. So that's why you need to take the course.
But I thought maybe because since you sent me to set up, which I appreciate you sending me there, and I've been clean for a whole year already.
Mhm.
My UAs and everything's been clean. They charge me $11 every time I go to UA. And that's the reason why I don't have that much money left over.
All right, so this is what I'm telling you. The month that's coming up, probation, don't charge him the $40 for that. You pay $25 for the class. They have a class online that is $25.
Another question, ma'am. I don't know nothing about internet or nothing like that on my phone.
All right, so I will tell you, if you go to the library, and maybe I'm wrong about this, but I think the library has free internet, free computers, free service for you to go in there.
So I have to go to a library then?
I mean, wherever you can go to complete this class, I'm telling you, the cheapest class that I found online was $25.
How long is the class for?
I do not know.
I have to do, how many?
We'll
It's a
look at it.
total of $25. That's
Okay.
all it is, $25.
Yes.
And so probation, I'm sorry, he really needs to do that course. So, yes. And I'm looking at it here now, course for theft awareness course, start now for only $25.
Judge, I will, I'll speak with Mr. Ramirez and get a little bit more information.
Okay. All right, thank you.
All right.
Thank you.
Oh, let me ask you this. Do you have a credit card?
Yes, ma'am.
All right. So yes, you can take this class online. All right, thank you. And then
No one at all, appreciate you for sending me through that. Is that on?
I'm so glad. I'm so glad.
It made me learn and from doing things that I want to do.
All right.
Quitting drugs, which I didn't want to do for a long time. That's why I had told Ms. Taylor.
Mm-hmm.
She was my probation officer. And they sent me over to set up. And I just want to appreciate them.
Oh, thank you so much. I'm glad it's working out for you.
I feel good.
All right, thank you. And I'm glad you requested a compliance hearing so I can know what's going on with you. Are you taking care of your eye?
Yes.
So you're seeing a doctor, right?
Yes, ma'am. I feel I'm.
All right, make sure you keep up with that.
Yes.
And probation, then once he completes that theft course, if you all want to file a motion for early term,
Yes, I already spoke with Mr. Garrigan and, he is on board with terming him.
all right. So once you complete that theft course, and it, from what I'm reading here, all it takes is a day. It's one class for $25. Yes.
I thought I had to go every week, so.
No, it's just a one-time $25 fee, and then you take the course and you're done. Oh.
Done for probation or?
Well, you'll talk to probation and probation will let you know, okay?
Okay, thank you, ma'am.
You're welcome.
Thank you, ma'am. Thank
Oh, thank you so much. God bless you too. Oh, you too.
No, phones, this, I need to tell the judge being put to paper, because Mr. Flowers. Had contacted, his phone is now disconnected, so. Flower, I guess it is. But you only work for the average. Come down sometime.
Yeah, how it works.
No, I thought you.
Gary Flower.
Judge.
All right.
You know, I've been.
Okay, is he on a PR bond? All right, court is calling 2024 CR 010795 State versus Gary Joe Flower Jr. Could I have parties announced for the record? State? Defense, excuse me, Deputy. Could you make an announcement for Gary Joe Flower Jr.?
Outside?
Yes, please. All right, this hearing was called at 9 a.m. It is now 9:46 a.m. The defendant has not made an appearance. Defense, have you had any contact with your client?
I have not, Your Honor.
All right, and you've tried to contact him?
Yeah. Get a message, the phone has been disconnected.
Okay. Deputy, did you make an announcement for Gary Joe Flower Jr.?
Yes, I did.
And
No
was it?
answer.
All right, thank you. State, what are you requesting? All right, the court will issue a judge's warrant, remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you, Your Honor.
All right, thank you. Have a great day. Arturo Villanueva? Oh, where's your attorney?
Outside.
All right, just have a seat. Once he comes in, I'll take your matter up. Have you all received any paperwork from the attorney? All right, let me, yes.
Johnson,
Mhm.
I sent paperwork to defense counsel and to the defendant, email address by Ferguson,
Mhm.
then to Concha, Ferguson. For you to sign, I have not received any notifications that the paperwork that I sent to the defense counsel has been signed.
Okay.
And it goes in.
All right. So let me see. So it goes from you to the council.
Me, the defense counsel, to defendant, to the clerk, I have to judge.
Okay.
Orders of signature.
All right. Let me let them know we don't have their paperwork.
Was Villanueva called? I was out in the
Yes,
hallway.
no problem. Hello.
Morning.
Good morning. Council on Zoom?
Yes, Your Honor.
Yes, my understanding from the state, they sent paperwork to the email that was provided to them, and they need you to sign it. So do you have any paperwork in your email?
Yep, we did receive it. I'll get it over to my client.
All right, so I'll put you all back in a breakout room so
Okay,
that you can sign the paperwork.
Okay, thank you.
You're welcome. All right. All right, council, I just sent a request for you to go to breakout room number 1. That's where your client is.
Yes, Your Honor, and I clicked yes. It looked like it was gonna send me there and then it kicked me back here.
All right, then what I'll do, I'll remove you to breakout room number 2. Let me
Okay.
know if you see that.
Yep,
All right, on Mr. Villanueva, last time we were here on motions.
That's correct.
All right, so where are we?
We've conferred on the motions, Your Honor. We have come to agreements on most of them. The state is gonna give me some 609 motion, some 609 discovery motion.
All right, so let's go on the record. The court is calling 2024 CR 0176 State versus Arturo Villanueva. Can I have parties announced for the record for the state? Defense,
Daniel Vela, Your Honor.
are you Mr. Villanueva? All right, so we were here previously, and for the record, the defense had withdrawn the motion for speedy trial. With regards to the motion to compel election between charging paragraphs, it reads as though defense, you want a severance of the accounts?
Correct, Your Honor.
All right. And did you file a motion to sever counts?
I filed the only motion I filed was the one that you have here, motion to compel election between charging paragraphs, which.
All right, so state,
in
you're
essence-
put on notice that he wants to have the counts severed. My reading of the law is that he's entitled to severance if the charging instrument alleges 2 different offenses. So if there's a disagreement on my reading of the law or my interpretation of the law, let me know. I'll be open to hear any type of argument. based upon case law as it relates to that. So state, do you need time for that? But it appears from reading the indictment that it is two separate offenses.
I'll need some time for that.
All right, so I understand what you're asking for. It's the court's belief that you're entitled to a severance of the counts, but I'll give the state a chance to review their case law and present it to you. So if y'all will email about that, all right.
Thank you, Your Honor.
And then I'll let you know when I'll set a hearing for that because you'll need to know sooner rather than later. All right, and then my understanding, the motion to quash an exception to the substance of the indictment, you withdrew that one.
That is correct.
The motion to suppress photographic identification.
However, the court wants to handle that, Your Honor, if they want to, if the court wants a different hearing for that matter, there was a photographic identification in this case that I would like to word dire the officer on. The court wants to run it with the trial or have a separate hearing.
All right, that may be a simple matter and we can run it with trial. Is there any objection to running the motion to suppress photographic identification with trial, state? Defense?
The only request I would have, Your Honor, is that no, I actually know, however the court wants to run that.
Okay. All right, and then the next one is motion to production of evidence favorable to the accused. I mean, state, you have to do that. I'm sure you're in agreement. Is that correct? The motion in limine. With regards to that, I don't know if any of it will be relevant or not. If it's something that's extraneous, and if I deem that it is admissible, I would also have to do a 404B balancing test. And so, yeah, I'm sorry yes, I'd have to do a balancing test to see if it's admissible. So on that, if y'all will just approach before state you seek to introduce any extraneous offenses or alleged misconduct.
Understood, Your Honor.
All right, discovery of exculpatory and mitigating evidence. State, I'm assuming you're in agreement with that?
We conferred on that one this morning, Your Honor. State's looking into that.
All right.
And in the process of getting DCS and CIC records for our land witnesses. It would be complicated with those witnesses. We don't have a date of birth, which is, I understand, necessary for finding those sort of records. So I have asked my investigator to assist me in finding a date of birth for that witness so that we can find those records and produce them.
Okay. All right, and then the motion for the witness list.
The state provided that to me this morning, Your Honor.
Okay. And then there's another motion in limine with regards to prior convictions. State, if you're introducing any prior convictions that Mr. Villanueva may or may not have, just approach. Because I won't know if it's relevant or if it's admissible until I hear the evidence. And I think you already talked about this one, the motion for discovery of the arrest and conviction records of the state's witnesses. You state that you're running NCIC, TCIC, and you let them view the results of that?
Yes, sir.
All right. So defense, the state is not allowed to give you copies, but you legally, they're not allowed to give copies of that, but you are allowed to view it. All
And
right,
cross-examine them regarding it.
yes. All right, the motion to suppress.
That is regarding the arrest warrant, arrest affidavit, and that, however, that's again another issue that, however, the court wants to run that with a separate hearing.
All right,
Or-
can you tell me, with regards to the motion to suppress, what is the complaint or the issue?
The arrest was, it was an at-large filing. And the reports, I'd like to go in, I'd like to address the underlying officer as to how the arrest was, his arrest warrant affidavit and how that was done.
All right, so there's an issue with the affidavit for arrest.
Yes.
All right, and how many witnesses are involved with regards to the affidavit?
To my understanding, just one.
All right,
The original, just the officer.
so that's your issue, and is there any other issue outside of the arrest?
Regarding the suppression,
Yes,
just that the arrest affidavit and the probable cause for the arrest, Your Honor, which goes with that. I'm
all
assuming.
right, and is that the same officer with regards to the probable cause? Because I don't know anything about your case. Was there a stop? Was there,
No,
all right, so it's only one officer that you need with
I'm not
regards to the affidavit?
it would be the, right, it would be the investigator on it.
All right, so then what we'll do is we can set this for a motion to suppress, and that will be done. We can do that the day before your trial. And what I'm gonna do, because I don't have access to certain information. We'll recall this back on, Lance, are we able to do this the week of January 13th? Are you available the week of January 13th?
I'm looking right now, Your Honor.
And off the
Yes.
record for a moment, yeah, I just signed the documents. You're available that week?
Yes, Your Honor.
And are you available that week? All right, then. So what we'll do, Lance, if you can give them a reset date for January 13th. And on that date, I'm going to give you a jury trial date and give you a date for your motion to suppress if it turns out there's more than one witness that's needed.
Fair enough, Your Honor.
All
Oh,
right.
excused?
Yes, once he signs the reset form.
Thank you.
You're welcome. Yes.
Notification that documents were not able to deliver to the defendant because the email address.
Okay. Let me see.
Correct email address.
All right, I just received something that I, okay.
Waiver stipulation for plea bargaining.
All right, just one moment. All right, yeah. Are you able to go into the
Thank you.
waiting room and let them know that we don't have the proper email address? Thank you.
Yes. Your Honor, may I be excused from the witness?
Yes.
Thank you, Counsel.
I see you.
So red.
Yes. Yeah. Yeah. I'm sorry. I found that there was no. Yeah. Should be in there. Okay. Always double check his.
I can't keep up though. Of course.
Court is calling 2024 CR 00862 State versus Joshua Pardo. Can I have parties announced for the record?
Lastly, Sahonovich for Mr. Pardo. Mr. Edelman's for the state.
All right, for the state. And are you Mr. Pardo? All right, you entered a plea on October 17th. According to the plea bargaining agreement, punishment is to be assessed at a cap of 6 years, and the state is silent on your recommendation for probation. Have both parties had a chance to review the PSI report, state,
Yes, Your Honor.
defense?
Your Honor.
Any objections to the PSI report, state? Defense?
And, uh,
Have both parties reviewed the TAP evaluation?
Yes, we have.
Any objections to the TAP evaluation, state? Defense?
No, Your Honor.
Any witnesses,
No,
defense?
no, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. He has been able to gain gainful employment. He starts Friday and it's the Beckhaver Foods. Over on Goldfield Road. He has never been on probation before for a felony.
I'm sorry, what?
He's never been on probation before.
According to the.
No, I mean, I'll let him finish because I'm looking at I see
Oh,
the,
okay, I was basing, if I'm mistaken, then, no, I apologize. I was basing, based on what my client. So I'll withdraw that part.
all right, so what I can tell you is he has been on probation for evading arrest, detention with a vehicle for 6 months, deferred adjudication. A motion to revoke was filed, it was withdrawn, and the case was dismissed. He was on probation for DWI in 2002. Probation was revoked and he was sentenced to 4 months in jail. He was sentenced to 6 months in jail for assault bodily injury in 2003. And also in 2003, 6 months in jail for interference with emergency telephone call. 2004, he was placed on DWI second probation for 2 years. His probation was revoked and he was sentenced to 6 months and 20 days in jail. 2004, he had a criminal mischief, $500 to $1,500. He was given 2 years probation. A motion to revoke was filed. The motion was granted. He was sentenced to 6 months and 20 years. 2024, he was charged with escape. He was given 2 years probation. A motion to revoke was filed. Motion was revoked. He was sentenced to 6 months and 20 days in jail. 2006, he was sentenced for assault bodily injury married to 4 months and 20 days in jail. 2008, assault bodily injury. The offense was reduced and he was sentenced to 60 days in jail. 2009, violation bond or protective order. He was placed on probation and MTR was filed. Probation was revoked. He was sentenced to 7 months and 20 days. 2010, violation bond protective order, 56 days jail. 2014, assault bodily injury. That was a felony. It was reduced to misdemeanor. He was sentenced to 1 year in jail. 2017, assault bodily injury family household, 5 months jail. 2019, criminal mischief, $750 to $2,500. He was placed on probation for 1 year. A motion to revoke was filed. Probation was revoked. He was sentenced to 90 days in jail. 2023, criminal mischief, $750 to $2,500. He was sentenced to 10 days in jail. 2024, terroristic threat causing fear, 80 days in jail. 2005, evading arrest, detention with a vehicle, 12 months state jail. 2010, possession less than a gram. He was given 2 years probation. The probation was revoked. He was sentenced to 9 months in the state jail facility. 2012, assault family second. He was given 5 years deferred adjudication. Probation was revoked. He was sentenced to 3 years in prison. 2014, possession, 1 to 4 grams. He was sentenced to 3 years in prison. And now we are here. All right. Anything you wish to say about your client's behalf?
Other than what I said previously, no.
All right. And state, you had something you wanted to say?
I did, Your Honor, but it's already.
All right. Anything you wish to say, Mr. Pardo?
I am terribly sorry.
You want to raise your right hand for me? Do you
Yes.
solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I swear.
All right, you can lower your hand, state your name for the record.
Joshua Javier Pardo.
All right, you stated there's something you wish to say?
I'm terribly sorry for
my behavior. I was on a reckless path. I didn't know. I also suffer from bipolar 1 disorder and PTSD. I wasn't on medication at the time. I have been trying to better my life for quite some time. My family is here in support of me. They have been very patient with me as well as I have tried to.
All right,
better
all
my
right. I
life.
still don't understand why you went to the Dollar Tree and threatened the employees
I
and
went-
start breaking items.
Yes, ma'am. I went, I didn't have my glasses at the time. I tripped over something and I thought I heard her chuckle and, I lost my, excited and took over. I knocked over, a stand, I believe probably $13 of damage. I was able to apologize to the cash, register woman and, she had told me that I wasn't allowed back at the store. I am on GPS monitor. I have been obeying everything.
Now, what it says in the stipulations, I'm not the one who accepted this plea, but what it says in the stipulation is that victim said suspect was verbally aggressive with them and that suspect verbally demanded money for an alleged recall of items from employees, victim 1 and victim 2 at the incident location. Suspect then started breaking items inside the store that were valued at approximately $13. Once he realized that he was not going to receive any money from the business. So there's nothing about you tripping over an item. It says that you went to the Dollar General, you wanted refund. They told you they were not giving you a refund. And then you proceeded to destroy items. And then you told them that you would shoot up the incident with the gun. So that's what you stipulated to.
I did say, Your Honor, that's why, that's why people ended up getting shot. But I did not threaten to shoot up the store. I have no way of getting a gun and, I'm not that type of individual to open fire or anything.
All right, the court is going to deny your application. The court is going to find you guilty. According to the plea bargaining agreement, punishment is to be assessed at a cap of 6 years in the prison. Defense? The agreement is cap of 6. Do you want to speak to the cap?
I think based on the facts of this case, we've asked the court to assess 2-year punishment. Judge.
All right, the court is going to find you guilty. The court is going to sentence you to 6 years in the prison, and the court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yeah.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. I'll recommend the therapeutic community for you. It doesn't increase the time that you're in custody, but it can help you perhaps with your mental health issues, any anger issues, or any drug issues that you have. You understand? I want you to know that I listened to everything that your attorney said. I reviewed the stipulations, even though I'm not the one who took the plea bargain agreement. And I reviewed the TAP evaluation, and I reviewed your PSI report. All right? So you're gonna have to start improving your life. You understand? All right, good luck to you. Dominique Camacho. Good morning. All right, I just received the felony packet, so I'm signing that. All right, court is calling 2024 CR 009127, State versus Dominique Camacho. Could I have parties announced for the record for the state? Defense?
Gable Sadowski, Judge.
And are you Mr. Camacho? Counsel, have you received all discovery and did you review it with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. Did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Counsel, is this an application for deferred?
Yes, it is.
All right, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented? Did you review the court admonishments and defendant's waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with assault choking? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand by giving up by entering this plea, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your probation were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Camacho, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, there's a $1,500 fine. State recommends deferred adjudication. There's an affirmative finding of family violence. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Correct, Judge.
State, is that the plea?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be no harmful or injurious contact with Brianna Cabrera. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary or custodial parent? Knowing that, do you still wish to continue with this plea? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Okay, for states exhibit 1 and all attachments.
No objection, Judge.
All right, and state, have you spoken with the complainant?
You have your.
All right, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, he's fully employed. He works in the oil field. He's sees his child. The mother of his child is the alleged victim in this case. And he sees the child who's paying.
Excuse me, if you all could talk on that end, the deputy will move towards that end. You may continue.
He's paying child support in that case, and he's trying to be involved and he's fully employed.
All right. So here's the thing. If you think somebody has cheated on you, you have two options. Either you accept it and don't bring it up again, or either you move on and say, you know what, I can't accept this. And you still don't bring it up again. The relationship is just over. Do you understand?
Yes, ma'am.
And your 11-month-old, is this a boy or girl?
Just turned 2.
All right, so let me explain something to you. Children mimic what they see.
Yes.
That's how children learn how to speak. If you have a son will think that you love his mom, because that's what children think. And if they see you being abusive towards their mom, they will think that's how you show love. Then they go on in their relationship and they be abusive. You understand?
Yes.
So I'm going to order no contact with Brianna Cabrera. What you'll need to do is y'all can do exchanges. Do your grandmother. I read in the police report that she discovered that he had taken the baby then 11 months to the grandmother. The only way I'll change that no contact order is if she comes in and tells me she wants the no contact order changed. But I don't do no harmful or injurious contact until I at least spoken to the complainant. So there's to be no contact with Brianna Cabrera. Regular reporting by Zoom or in person. Regular random UAs. There's an affirmative finding of family violence. Proof of employment within 30 days. No employment as a home health care provider or with minors. 100 hours of community service restitution. I'm going to order parenting classes. Once you complete the parenting classes, the community service hours will be deemed satisfied. With regards to was Child Protective Services ever involved?
Yes, she actually made me take a fatherhood class it was a 9-week domestic violence class that I took.
Mhm.
And it was her recommendation, so I took it and I did the 9 weeks.
When did you do that?
I did it, I can look at the email when I finished it, because it was like a couple months ago
All right.
before I moved to Odessa.
Judge, is there a chance that, I understand the court's position so far is no contact, but in light of the fact that he is an active participant in the rearing of his child, is it amenable to the court to have Family Wizard as a form of contact? Because Family Wizard allows all that communication to be done in writing electronically. And so if there is an issue with that, then they don't have to wholly rely on an intermediary, which is the grandmother.
All right. My order stands. Once the if the complainant comes in, and they can come in by Zoom if they want to come in by Zoom, if they have no issues, and if he's completed the courses as he said he's completed them, then the court will reconsider.
I can provide email and stuff as well.
All right. I'm gonna order the BIPP course, probation. If he has completed everything through CPS, and that was the parenting classes and the family violence course, then that will be acceptable to the court for the BIPP and the parenting classes. What is your off time from working?
I work 6 days a week, Your Honor, Monday through Saturday, 7 to 5.
All right.
Sometimes even more.
All right, there's gonna be field visit one time. Probation, is there anything else?
You just want it one time period, then?
Yes.
Nothing else.
Another county, but that's.
So Judge, he works in Permian Basin. He's in the oil field.
All right,
So
so where
he's-
does he live though? Does he live in Bear County?
I live in Odessa.
All right, probation, he lives in Odessa.
Are you giving him permission to transfer, Judge?
Yes.
But I frequently travel, like, obviously, I Odessa a lot because I'm a parks runner, so I constantly.
All right, let them know. And what county is Odessa?
I don't,
I'm sorry, what?
I'd eventually get that out of the 254 judge, but I didn't.
Okay. All right, so he's allowed to transfer to Odessa County. I'm sorry, Odessa, Texas, which is Ector County. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. In this court, to be successful on probation, communication is key. If you have an issue, let probation know. If there's an issue and they say that you can't travel, don't just stop reporting. Let probation know. If you feel as though they're not addressing it, you can always come to the court and address it with me. All right, thank you for dressing appropriately for court. Once you go over your conditions, you'll be excused.
Judge, may I be excused?
Yes. All right, who's here on Jose Escalon? Okay, thank you.
Morning, sir.
All right, today is plea deadline date.
Judge, he's been accepted in the PTD.
Okay.
I've already talked to Lucy.
Mhm.
She emailed us contract on the 3rd of this month.
Okay.
I emailed it back to her on the 9th. She didn't get it.
Okay.
And so we're here today. I talked to her, I got it, and she said that he should be in there in the next week or two.
All right.
So I'm gonna send him over there after that, today. He has the address for the bill and everything.
All right, Lance, can you give me a reset date for 30 days on Escalon?
Thank you, Judge.
Sure. And it's for a pretrial diversion.
Of January 16th.
All right, January
Hold
16th.
on one second. I think that'll work. I love it. Let's do it.
All right, so January 16th. And of course, if he's completed everything and
Yeah,
it's
no-
dismissed, he won't have to come.
Do you understand that? What happens if you're in, so if you get on the ball and get everything done, they're gonna dismiss the state, right? So you gotta be proactive, all right?
All right,
Alrighty.
and counsel, if there's any issues, just let the court know.
Thank you, Judge.
And once he signs the reset form, he's excused.
Yes, ma'am.
Thank
Alright.
you.
Well, see-
Luis Briceño. Good morning. You're still confident about Pittsburgh?
Eagles are tough. Eagles are tough. Eagles.
Oh, I'm not jinxing it. That's your football buddy.
I know.
He doesn't seem very confident.
It's tough.
Mhm.
They're favored.
He said it's tough.
We haven't won there since 1960.
He said you all have not won there since 1965. Is today the day? I don't know.
I was actually there last time.
Oh,
We
yeah.
got destroyed. It was not
Oh.
in Philly.
So Vashawn, I don't know if you know about him. He will post when he's at the games. He's all decked out, right? And he said he was there at the last time they played and it wasn't fun.
It was not.
Were the Philly fans at least nice to you all?
They were nice until they started to destroy us, and then they were not nice.
Then they're like, hey, why are you wasting our time?
Unfortunately, my wife was like 8 months pregnant, so
Yeah.
they weren't too.
Oh, see that now that's a memory. She's gonna say, I remember that. I was 8 months pregnant.
Yeah.
And they didn't win. Hey, I think you guys will win this time. We'll see.
Good
All
chance.
right, so on this case, where are we on discovery?
So this is the first setting. There was I spoke to Mr. Garahan about it. There was absolutely no discovery in the system for whatever reason. I don't know why that is. So he was, I guess, working on it.
All right, how old are you?
Sorry.
That's okay. People say that all the time. No, that's okay. So are you in school?
Yes, Your Honor.
All right, so what is your, no gum chewing? That's okay. Don't you get
I'm getting
Oh, I just swallowed it, sorry.
Oh,
Oh,
okay, you know what people would always tell us if you swallow gums that it'll stick to your
7
intestine
years.
and you're not gonna survive? Don't swallow gum. Who knows what can happen to your intestines? All right. So what I'm gonna do is I'm gonna reset this for, can we set it for 45 days for discovery?
January 30th?
All right, and let me ask you this. You say you're in school. Are you in college?
Yes, Your Honor.
All right, so then what we'll do, are you in college here in San Antonio?
Yes, Your Honor.
Which school?
San Antonio College.
All right, so then what we can do, because I don't want to interfere with tests or
Right,
anything of
hold
that
it down.
nature. If you want him to appear by Zoom, because it's a discovery setting, he can appear by Zoom.
Okay, I'll put it in there.
All right, so we'll see you back on January 30th. All right, once you sign the reset form, you're excused, make sure you include your email on that so they can email you.
Okay.
All right, thank you.
Thank you.
Thanks, Judge.
Hello, how's it going?
Tired. Y'all have trials next week?
No.
Oh, thank goodness.
I would be a Grinch if I were to put people to trial next week.
I'm up for trial Monday in another court, so
Ah,
I'm really trying to get here for another jury trial. All right, y'all doing a Christmas party this year?
oh, yes, we always. Bye.
See you, Lance.
Mr. Persino.
You need this email address. Oh. But thank you for coming along with me. Yeah, right. Give me a break. I'm happy to have one. I really do want. Thank you. Yes. That is. Thanks for helping. Yes, sir.
Yeah.
That's why you get hired.
All right, so you're done? Yes. Okay, let me close one.
Mr. Porter, so I can get to the dentist.
Court is calling 2023 CR 1221 State versus Joshua Johnson. Can I have parties announced for the record for the state? Defense,
Joseph Redvelt for Mr. Johnson.
and are you Mr. Johnson?
Correct. Yes, Your Honor.
All right, we're doing this hearing by Zoom. Mr. Johnson, do you waive your right to appear in person?
Correct. Yes, Your Honor.
All right, the court will find that defendant has knowingly and voluntarily consented to appear by Zoom. Counsel, have you received all of the discovery? Did you review it with your client?
Yes, I have, Your Honor, and I've reviewed it with Mr. Johnson.
Court will find that the state is in compliance with discovery. Mr. Johnson, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sir.
Mr. Johnson, did you review the document entitled Court Admonishments and Defendants Waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, the court does not have an application for deferred adjudication. Are you applying for deferred adjudication, Mr. Johnson? Mr. Johnson?
Yes, Your Honor.
All right, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this agreement you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into an agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Defenses, no, Your Honor, but statements that we'd be able to use at trial, yes.
All right. Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Johnson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Very satisfied.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at a $2,000 fine, and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
That is the plea, Your Honor.
State,
I believe
is
there's
that-
also a tap. I believe there's also a tap evaluation in there as well.
All right, state, is that the plea? All right, let's go out the record for a moment. So everyone, you all need to whisper. And who is standing behind you, Andrew? Hi. They can move your guy at the top or further down, at least. No, not behind the court reporter, just further down. All right, we're back on the record. State, is that the plea? Did you review the waiver of appeal paragraph, Mr. Johnson, with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be 200 hours of community service restitution, and that there be no contact with Christopher Saldivar. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
That is plea, Your Honor.
Oh, I'm so sorry. I'm a little bit distracted because I don't have the trial court certification of defendant's rights to appeal.
I'm sending that to him right now.
All right, thank you. All right. Did you understand that those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
All right. Then to the offenses charge, how do you plea? Guilty, not guilty, or no contest?
No contest.
State, any evidence? Any objections?
No, Your Honor.
All right, off the record. So counsel, the coordinator is sending you one, the application for deferred adjudication, and also the trial court certification of defendant's rights to appeal.
Okay.
All right, we're back on the record. Mr. Johnson, did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
And state you may be excused. Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. State, have you had contact with the complainant?
Personally, no, Your Honor.
All right, so why should I follow this agreement?
I believe the agreement was negotiated by Eric and Your Honor.
Sorry, Judge, you asked the state or you asking me?
The state, yes. So has there been contact with the complainant? All right, while they're reviewing that, tell me about your client, counsel.
Your Honor, I've been practicing law. I think it just started my 19th year, specifically in criminal defense, then retired duration. Mr. Johnson's one of those clients. He's been very diligent from the start. He is working very closely with me. His mother has been very close contact with me. He does everything that he's supposed to do. He works. He hasn't violated any terms of his bond. He's very, very much active in this matter and wants to do everything right. This is his first time ever being in trouble. He's accepting this plea. He accepts the fact that he has to plead no contest to the facts as is. In my investigation of the case, although the complaining witness spoke with me once, he did not want to go through any type of detail as to what happened. There are some discrepancies as to what the officer found versus what the alleged victim had written in his statement. And Mr. Johnson did give a voluntary statement over to the police at the time of incident as to what occurred. So I think the allegations as put forth by the CW are a little bit exaggerated, although there was a brandishing of a firearm in a what I guess would be considered a semi-road rage incident in San Antonio. So Mr. Johnson was open with the officer, admitted to what happened. He's shown remorse. I really truly believe that he is deserving of a chance of a deferred adjudication, probation, and to prove to the court that this is going to be a minor glitch, although serious glitch in his life that he will come to terms with. He will do as the court deems necessary to prove that he deserves this chance and have his adjudication deferred.
All right, state.
Yes, Your Honor, yes, the complainant was spoken with by the DA's office, Dan Escobar. He actually stated that he didn't believe that the individual didn't have a long history, that the defendant not be punished too harshly for something that he thought was a really stupid mistake on the defendant's part.
All right, thank you. All right, Mr. Johnson. I receive information for the complainant. Sometimes I see agreements and I will ask why I should accept these agreements, but I understand in this case why the agreement is what it is. Is your client in Bear County still or no?
No, he's been in Houston the entire time, Your Honor. He was in Bear County just briefly during this incident.
All right, so somebody want to tell me, and I'm embarrassed to say, what county is Houston?
Harris.
See, I always think it's Travis, but it's not. It's Harris. Okay. Court will sentence you to 5 years, deferred adjudication, $2,000 fine, probated, regular reporting by Zoom or in person, regular random UAs. There's an affirmative finding of deadly weapon, transfer to Harris County. Are you employed?
Yes, ma'am.
What do you do?
Currently, I just started a new job, which is on the 16th. I'm going to be an associate with CT Sounds. CT Sounds is a car audio appliance company. So I'm
Okay.
going to be doing that for a year. Then after that, I was also, I wouldn't say promised, but guaranteed to be a manager for the company as well, making a higher salary. This week, Tuesday was my last day with Daikin and their HVAC assembly company. So with them, I was doing the installation.
All right. So there's proof of employment within 30 days, no employment as a home health care provider with minors. There's to be no contact with Christopher Saldivar. Do you have any children?
No, ma'am.
Oh, wow. Yay. Feel that once you have your life in order, then it's time to, if you want to have children, it's time to formulate a plan. All right, how far did you go in school?
I'm sorry.
How far did you go in school?
High school, I have my diploma. And then I want to say I did 2 years with Lone Star College Side Fair in Houston, Texas. Additional schooling, I have my real estate license. And then I just finished and graduated last month on November 14th, my cybersecurity cohort class. Right now, I'm just studying to take the CompTIA Security Plus exam.
All right, the court is going to order 200 hours community service restitution if you provide proof of your real estate license and if you pass this cybersecurity test that you're taking, the community service hours will be deemed satisfied. And I'm going to order anger management. Yes.
My
I'll-
license, right? Go ahead.
No,
I'll
go ahead.
explain it to me. Oh, it probably his real estate license is probably suspended as a result of the open case, Your Honor.
Well, I know it's inactive. I haven't searched Texas Real Estate Commission website to see if it is suspended. I
Well,
can
if
check
you have
today.
proof that you've had a real estate license and you passed the cybersecurity test that you say that you're going to take, then the court will deem your community service hours satisfied.
Okay.
And
Your
the court
Honor.
is going to, yes.
Go ahead, Your Honor. I don't want to interrupt. I'm sorry, I did.
Court is going to order anger management classes. Probation. Is there anything else he needs? Yes. Is there anything else you need from the court in order to be successful, Mr. Johnson?
No, ma'am.
Question, Your Honor. The anger management, what level are you wanting him just to do the online course or a course through probation? with multiple classes?
Probation will let him know the acceptable course.
Okay. Lastly, Mr. Johnson is currently on an ankle monitor as part of his bond conditions. Would Your Honor
Any
sign an
objection
order
to
for the same?
removing of the ankle monitor?
State requests that Mr. Johnson appear in person to provide his
All right.
I didn't hear what you said, but
He wants him to appear in person to provide a thumbprint, his thumbprint. All right, the GPS will be removed. And then I am still awaiting from you. They're going to send you an email. I need the trial court certification of defendants' rights to appeal. Did your attorney go over the trial court certification of defendants' rights to appeal with you, sir?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. With regards to your the request for a fingerprint. Probation, can you see if it can be coordinated in Houston with him providing a fingerprint to them on a copy of a judgment?
Yes.
Otherwise, you're gonna have to come back to San Antonio to do that. All right,
Yes,
I'm gonna send you all to breakout room. I'll send you all to breakout room number 1. And please do not leave until you have signed that trial court certification of defendant's rights to appeal.
Will do, Your Honor.
All right, thank you. All right, they'll get that to you. You're welcome. Eduardo Porter III. Court is calling 2024 CR 008-136, State of Texas versus Eduardo Porter III. Could I have parties announced for the record for the state? Defense,
Kagan on behalf of Mr. Porter.
are you Mr. Porter? Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Mr. Porter, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it? Court will find that the state is in compliance with discovery. Mr. Porter, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We'll waive it, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor, proceeding on counts 1 and 2 and waiting.
Any objection?
No objection.
Did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand that you're charged with aggravated assault with a deadly weapon in each count? Those are second-degree felonies. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent? Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked in each count, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
He most certainly has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes to both.
Mr. Porter, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, the state is proceeding on counts 1 and 2. Punishment is to be assessed at 7 years in the prison. There's a $2,000 fine. It isn't checked off, but if the court were to find that there was an affirmative finding of a deadly weapon, or at least a deadly weapon was used, the court will make an affirmative finding of deadly weapon in each count. Did you understand? There's to be restitution, if any, to Brandon Taylor, and the state is silent on your application for deferred adjudication. Did you understand that to be the plea? Defense, is that the plea?
That's our agreement, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No.
Outside the agreement, there's to be no contact with Brandon Taylor. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation? Then to count 1, how do you plead? Guilty, not guilty, or no contest?
No contest.
To count 2, how do you plead?
No.
State any evidence.
I've reviewed those documents previously with my client. We have no objections.
State, you may be excused. Did you review the waiver and consents with your to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Do you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty of counts 1 and counts 2. The court will defer finding of guilt as you've applied for deferred adjudication. We'll set this for a PSI and we will come back. And at that time, I'll make a decision on your application based upon the PSI and the TAP evaluation and whatever evidence is presented. Do you understand?
Yes, sir.
All right, Lance, I need a PSI date on Porter.
February 4th.
All right, so we'll be back on February 4th. Do not leave the courtroom until you've spoken with probation, okay?
Yes.
And you'll need to do a reset form. Once you sign that, please include your email. All right, thank you. Thank you for dressing appropriately. Theodore McCullough.
You want a PSI and
Yes. Court is calling 2023 CR 5612, State of Texas versus Theodore Joel McCullough. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
John Hector Garza Jr.
All right, and are you Mr. McCullough?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Theodore Joel McCullough who was placed on community supervision in 2023 CR 5612 for the offense of evading arrest, detention, second or more on July 26, 2023 for a term of 4 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violating condition number 4 in Drew County, Texas, defendant Theodore Joel McCullough was in there, failed to report to the supervision officers as directed for the month of April and August 2024 violation.
How do you plead to that? True or not true?
True.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you to 3 years in prison and up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor.
Yes.
It is the grant the motion to develop the individual off of probation. But it's been 2 years in the Texas Department of Corrections.
All right, is that the agreement, counsel?
Agreement on 2 years and giving him credit for any time he served.
And Mr. McCullough, are you asking the court to follow that agreement?
Yes,
Are you waiving your right to appeal?
yes.
All right, then the court will follow your agreement. The court will grant the motion, sentence you to 2 years in the prison, and give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, I'm going to recommend the therapeutic community. We can go off the record. Here's the thing. If you continue thinking the way you think, you're going to spend the rest of your life in prison or in somebody's jail. You understand?
Yes, ma'am.
According to the court summary report that the court received, you need to do better. You understand?
Yes, ma'am.
And tattooing reckless on your head is not a good thing, because what you tattoo on your body, you start believing it, you see it every day. You understand? All right, when you're released from prison, if you need help with anything, with drug treatment or housing or something, if I'm still here, you can come back here. I'll pick up the phone to call somebody to help you. But don't pick up any new cases, you understand?
How much time ready do I have?
You'll have to speak to the clerk about that.
All right, that's not, thank
You're welcome.
Tomorrow. Oh, yeah.
Yes.
Johnson, and attorney wanted that, but they wanted to adjust as well.
All right, Mr. Johnson. Let me
I-
close the breakout rooms and hopefully he'll come in. So as soon as he comes in, I'll take that matter. All right, what issue did you all want to address?
I did not know if Bear County, since Your Honor had taken the electronic monitoring off of him, I don't know if he owes anything. I know he pays $300 a month for that. I don't know if Your Honor would be willing to waive any money that's owed so that he doesn't get turned away at the desk because
I
of
can
not.
say it's waived, but what I can tell you is regardless of whether he owes money or not, I've ordered that the GPS be removed, so the GPS be removed.
Perfect. Thank you so much, Your Honor. I really appreciate it.
You're welcome. Oh, and okay. All right, I'll see you all. Bye-bye.
Happy holidays. Bye-bye.
Thank you,
Thank
you
you.
too.
I'm excused, correct? Just want to make
Yes,
sure.
you are.
All right, thank you.
You're welcome. I will tell you, that's the first person who's been accused who can work Zoom better than anybody. He would go to the room, it's done. Oh, and Yaya, I received the other motions for Mr. Johnson, so I signed them.
Do you go by Yaya or is that just Judge's name?
Oh, no, they tell me to call her Yaya because I can't pronounce her first name. I can't roll my R's or do any of that.
Yeah, Haida. No, I know, but
See,
does
I
everyone
tried
call you-
Yahida and they tell me it was wrong.
No, yeah, Haida. My husband has the same problem, and my son's teacher is Miss Suarez. And he says he says Suarez. I don't know.
Okay,
But
that's
he-
what I say too.
Yeah. But he said he knew someone growing up with that last name, and he said, I always said Suarez. And my 5-year-old corrects him, Daddy, it's Miss Suarez.
Let me just tell you, I could not say Perez. And then somebody said, Stephanie, can you say petite? I'm like, oh yeah. They're like, there you go. So they're like, do it that way. And so in my mind, I'm really saying petite. So I'm like, Perez, Perez. And they're like, oh, you have it. So I still can't roll my R's though.
Yes.
Yeah, we're gonna apply for a recovery role. So
His name is, Gauss.
What's up, Legs?
Nothing. Absolutely not.
All right, on Edgar Aguilar, if he's here, we need an interpreter.
He's not out yet.
Okay.
Are we starting?
They're supposed to be doing a motion to suppress. State, do you have your witnesses on? Morrison?
Yes, Judge, you're present in the waiting room.
All right, where's the defense counsel?
Here, Your Honor.
All right, where's your client?
In the back.
All right, if y'all will come up. State
Yes,
and
Judge.
everyone, if you all continue to confer, I'm gonna handle this motion to suppress. Yes, thank you. Oh. I already turned in the file, so if you just put that in the file. All right. And if y'all want, you're more than welcome to do it from the table. Is this gonna be a long? All right, sure. Just have a seat at the table. All right, court is calling 2023 CR 4707, State of Texas versus Christopher Morrison. Can I have parties announced for the record for the state? Defense?
Shannon Locke for Christopher Morrison.
And are you Christopher Morrison?
I am.
All right, we're here on a motion to suppress. And what is the issue, state and defense?
So, Your Honor,
Yes.
we filed a.
Just one moment. She needs to give you a mic. And everyone, please have a seat. And counsel, do you have a copy of your motion to suppress?
So it's a motion for.
I don't have the motion. Yaya, do you have a motion to suppress on this? It's on Morrison. It's 2023 CR 4707.
Here.
Oh. All right, thank you, counsel.
So it is actually a motion for an evidentiary hearing.
Oh, we're having a hearing, but
I
you,
I understand.
Yes.
I'm just letting the court know.
okay,
It's a motion for a Frank's hearing.
okay.
Based on what we think are pretty clear misrepresentations in the search warrant affidavit.
All right.
And just briefly, I mean, my position is that the defendant is not entitled to the hearing on the motion on itself. Mr. Locke, or the defendant, has not alleged any knowing and intentional or reckless disregard for the truth. And so that is the law under Franks, and so that's why.
All right, I understand the state's position. I will let defense have the hearing, but I want everyone to be clear. This hearing, we're only focusing on what's in your motion and what your allegations are. So there's not to be, we're doing a full cross-examination for jury trial. We're here for this specific issue only. Does everyone understand?
Yes, Your Honor.
All right, state, you can call your witness.
State calls.
And so, Judge, I believe under a Frank's hearing, I think that the burden is mine.
It is your burden, but she has the witness here, so I'm just asking her to put the witness on the stand. Unless you subpoenaed him. All right. And I'm assuming someone is going to enter into evidence the affidavit so that I can view it?
Yes, I have that.
And defense, are you going to object to the state? Because you have the witness, are you going to object to the state entering into evidence the affidavit, or do you wish to do that?
Oh, that is absolutely fine if the state enters it in now.
All right,
Would you like me to acknowledge? this?
yes.
So, state offered, the affidavit for search warrant under Rule 915.
All right, and then we can label this as State's Exhibit A. Any objection to it being labeled as State's Exhibit A, defense?
No objection, Your Honor.
And any objection to State's Exhibit A being entered into evidence for purposes of this hearing?
Purpose of this hearing, no objection.
All right, could you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand if you'll state your name for the record, please.
Are you certified?
Just 1 second. Defense.
Thank you, Your Honor. Good morning, Detective Henning. So do you have a recollection of swearing out this search warrant affidavit?
Yeah, I read it.
Okay, so you read it this morning?
Yeah.
Before then, did you have an independent recollection of the search warrant affidavit? Swearing it out? So did you speak to anybody when you were gathering this information? I'm talking about when you swore out the affidavit.
Yeah. Not here.
And who did you talk to?
It was, first it was Sergeant Bill Cueva, then it was,
And did they summarize a conversation that they'd had with an officer, Izaguirre?
I don't know if that's time I knew the name of anybody.
Okay. So they summarized the conversation that they had with the person you would identify as victim number 1. Is that right?
Yes, they gave me information.
And when you say they, did you speak to them together?
I don't remember if I spoke to them independently or they were the same time.
Did you keep your body cam on when you talked to them? Yes.
No,
So you spoke to them over the telephone?
yes.
Okay. And you don't remember if, so if you're speaking to them over the telephone, it's likely that you're talking to them individually. Is that right? Okay. Do you remember who told you that the incident happened between 1945 and 8 p.m.
No, it's not. Whatever they told me then, I don't have the answer to that much.
But you don't remember who told you that?
It was one of the detectives, but I can't tell you which one.
They told you that, so that was from them.
Yeah, I didn't have any information.
And when a victim or when a police officer speaks to a victim of crime, those conversations are typically recorded, correct? Is it the San Antonio Police Department's policy to record those conversations?
Yes.
Did you ask them how many times they'd spoken to victim number 1 or victim number 2? But you would expect via Real and Garcia to have recorded those conversations. Is that right?
No, Sergeant Villanueva was in office,
Okay. But you would expect them to record those conversations as per the policy, correct?
Yes.
And you remember who told you that victim number 2 was swimming and victim number 1 was standing outside the pool?
Individually.
But it was one of those. And that victim number 1 then heard a muffled popping sound.
All the information there was from the detective. I can't take this one.
So you never spoke to victim number 1 or victim number 2 independently. You relied on Villanueva and Garcia and Rodriguez, I suppose, to summarize that conversation or their conversations with the victim.
Sergeant Villanueva spoke to the victim's office.
And that's nowhere in your report that only Garcia was one.
So Detective Garcia, Detective Rodriguez, Sergeant Bill and Wade just walked over to my office and asked my help.
I see. Garcia and Rodriguez spoke to the victim.
I don't know which one spoke to them individually, but I wasn't there. Just the information.
And all of the information in this affidavit was from them.
Yes.
Now, when you summarized this, you were assuming that they were telling you the truth.
Like I said, I just got the information from that.
Do you have access to their body cams?
The one that they were reporting the victim.
Yes.
No.
You did not have access to them.
No.
And then once their interaction with the victim was over, you could have had access to their body cams, correct?
Not while they're still there.
At some point, you could have gotten access to their body cam.
Yeah, days later.
And you were relying on them to tell you what happened.
Yes.
I have no further questions, John.
All right, any questions, State?
Yes, briefly. Detective Henning, so who contacted you to conduct follow-up investigation on December, I see, 22.
Sergeant Bill and Wade asked.
Okay, and when he contacted you, where were you?
I was in the third floor headquarters.
Okay, and were you assigned to the call out there?
No.
And typically when you're in headquarters, is your body worn camera on and off?
No.
And so when Sergeant Villanueva contacted you, for you to assist on call, what was your process in receiving the info for the application?
I got that.
And which detectives were those?
Detective Garcia.
Okay. And is it the normal practice of SAPD to contact the detectives that are on the scene investigating to receive the information for the search warrant?
Yes.
And regarding search warrants of residences, depending on the type of evidence that is trying to be seized, how important is the timing of getting that search warrant?
Well, it's imperative.
And so as you stated, because the call was ongoing at the time, you were unable to access the victim's statement at the time you were contacted, correct?
Yes, that's correct.
And when you received the information from Detective Garcia and Detective Rodriguez, did you have any reason to believe that they were being untruthful with you regarding their summation of the victim's statement?
No, I have no information about the case.
Okay, and when filling out the search warrant affidavit, did you knowingly or deliberately include a falsehood in that affidavit? Okay, and did you believe that Detective Garcia and Detective Rodriguez were telling you truthful information at the time?
Yes.
So you relied on them to accurately convey the conversation they had with the victim. And did they summarize the conversation in writing at all?
Not to my knowledge. No.
They were just talking to you verbally.
Yes.
And did you find out whether or not Mr. Morrison was still in the apartment while you were looking for that, while you were attempting to get that search?
I didn't know at the time.
Whether or not he was in the apartment or if he'd been transported somewhere else, that would make a difference to how urgent it is to get that search warrant. Do you agree?
I believe he was in custody at that point, but I don't remember. I don't know if he was in the apartment or where he actually was, but he was in custody.
Right, you can do the search warrant. If he's in custody, that urgency isn't as extreme as if he's about to come back to the apartment or out and about or something like that. Do you agree with that?
Lester.
Further questions?
Nothing further.
All right, thank you. You may step down. Any other witnesses?
Judge, I believe that can make you ruling. I do have the other detective here, to hear from them, but-
Is there someone else you wish to call?
Yes, Your Honor. So in the body cam,
Who do you wish to call?
Villanueva or Garcia, whoever it was that spoke to the victim,
All right,
or Rodriguez or Garcia.
state, if you all can determine who spoke to the witness. If you can raise your right hand, do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, if you state your name for the record, please. All right, you may have a seat. Defense?
Morning, Detective Rodriguez. You remember investigating the incidents that occurred at the Rivera luxury apartments? That was in early June of 2022, is that right? You spoke to an officer Izagire, is that right? And Officer Izagire was living at the Rivera luxury apartments, is that right? And as he was living there, he was basically a courtesy officer at that apartment complex. Am I right about that? You spoke to him, correct? How many times did you talk to him about this case? Just one time? Yes. Okay. And when you spoke to him, your body cam was on, correct? And for a little bit of the conversation, the body cam was muted, but at some point you turned the camera on, correct?
It wasn't muted, it's just the first 30 seconds is silent.
Okay. And then, so I guess it automatically turns on?
Yeah, once I activate it, it's silent for 30 seconds and then turns on.
Have you watched the video of you talking to the complainant? Okay. You'd agree that it's not the same as Detective Henning's affidavit? Your conversation with the victim, your Officer Izagire, is different than what Detective Henning put in his affidavit. Okay. Your Honor, if I could approach the witness?
Yes.
This is Great. So I think the state has a copy of the body cam conversation.
All right. Do y'all want to label that as Exhibit B for
That's fine.
purposes of this hearing?
That's fine by us.
Yes.
All right. Then it would be labeled State's Exhibit Number B. And that is admitted without objection for purposes of this hearing?
Correct, Your Honor.
All right, thank you.
Your Honor, may I approach the changes?
Yes.
Let me just, Your Honor, if I could just ask a couple of questions to,
Yes.
thank you, Your Honor. When you spoke with Detective Henning, you told him the truth, correct? You accurately conveyed the victim's statement to him, correct? And you didn't fabricate anything during that conversation, did you? Okay, and was your body cam on when you talked to the detective? And you've authenticated, you've watched this is the video that you watched previously? There's no alterations to that? Go ahead.
So, the event. About what time did this happen? Was it right when you called?
Yeah, so no, we got out to the pool about 7:15-ish, sometime after 7 o'clock, 7:15-ish.
So he told you that he got to the pool at 7:15, correct? Okay, and Detective Henning put 7:45 to 8 p.m. because that's date. Is that correct? Better if I could approach the witness, and I'm not sure we're.
So perhaps, I think you all have State's Exhibit A. I do not have State's Exhibit A. So perhaps if there are specific items that you're saying that were told that you believe are incorrect, if you'll just focus on what you're saying is different from what's in the affidavit, then that will move things along.
That's what I'm
Okay.
planning on doing.
All right.
So you said 7:15, it says 7:45 on that.
Okay.
That's the.
All right, no problem. If you'll just point to her where in the affidavit.
If I could approach the witness.
Yes.
So you told Detective Henning that this happened about 7:15 according to Officer Eating. Is that right? But Henning put 7:45 to 8 p.m. Is that right?
Okay, so, the event. About what time did this happen? Was the right called?
Yeah, so, no, we got out of the pool about 7:15-ish, sometime after 7 o'clock, 7:15-ish. We got out to the pool, when we first got out here, I put my stuff down, I put it down on one of the little big chairs right here. And Mikey and I put on his little location device, his vest, and we were standing right here on this platform, he was playing around in there. He wanted to actually go into the pool, so I moved our stuff and I put it on the chair over here. And once I did that, we were sitting down where, like allegedly the stairs went into the pool. We were sitting there for a little bit and he actually wanted to go further out, so we started going, we were swimming. While we were swimming, we went from the stairs, maybe 5-6 feet up. We were kind of like in the center of the pool area. And I couldn't tell you how long we were in there for. But we were there for a few minutes, and one of the first times I heard the splash in the water, I heard something hit the water, and I looked on my peripheral my vision, I saw the water kind of fly.
So he says that he's in the center of the pool, correct? Okay, and that's when he hears, after they've been swimming for a few minutes, that's when he sees a splash and something fall into the pool, correct? Okay. He did not say that he was standing outside the pool, correct? Okay. He says that he is in the pool with his son, correct? Okay, and what does the search warrant affidavit say about where he was when he heard the first impact on the water? And it's the second sentence of the affidavit.
Number 2, report is in the pool while the police started. Then number 2 was reportedly swimming in the pool. Number 1 was the area outside the pool.
So I kind of looked like that. I saw some birds flying around, and I thought that bird freaking died and went in the water. So I walked kind of back where I heard this splash, and I'm looking around and I don't see a bird.
So it sounds then after he heard the first splash, then he gets out of the water, correct?
If I were kind of getting closer to the edge, Mikey was about maybe 3.5 feet behind me, because I could hear him swimming, and then I heard another loud splash, another splash, and I turned around and I looked at Mikey, like, what the hell is that? I thought it was him splashing around that time. I didn't see the water come up this time, but I heard something hit the water really loud, and I heard the water like splash up. Go over and I thought I was him. So I'm looking around, and when I heard that, I heard that's all it sounded like a small little report, almost like somebody just shot their hand.
Yeah.
So I'm looking.
So he reports observing 2 impacts on the water, correct? And he says he doesn't call it a muffled popping, does he?
Makes a noise.
He makes a noise, right? And then he
What the hell is that? So we kind of start swimming some more, and then I hear it again. And I just hear it, and this time I see it hit the water right in that area, right there by the pool again, and I'm like,
About how far do you think it was from you, where we're sitting?
from where I was at, like 2-3 feet, I would say. So then I was like, what the hell is going on? So I grabbed Mikey and kind of moved a little bit, and then I heard it again. And that's where I heard it hit like a window. Like I heard the little clap, I heard the window shatter, and then I started looking around, and it's pretty gun or telephone. So I'm looking around, and I didn't even realize that window was broken. And I grabbed Mikey, and back it up. I put Mikey right here behind like where this little pillar is at, the rocks. I put Mikey and I stood right there, just kind of like, where the hell is this coming from? So I'm looking around, and then the only door that I saw that was open to any of the balconies was the one right here, the 251, apartment 251. I'm looking in there and the sliding door is open and the blinds are kind of separated at the bottom. And I can see like it's like a silhouette of a person's head there and something he was holding something, I just couldn't tell what it was. And when I'm looking, all of a sudden that's where I hear the and that's when I knew like, oh fuck, that was messing with like a gun or something.
Yeah.
And anyways, when I hear that and I'm looking around, I hear it again. And that's where I made that contact with the guy. And the guy.
Where was he at?
So it's from like if I'm standing right here, not on the grass, but on the concrete right here, I'm looking up to where the second on the floor. He's in his apartment, he's behind the blinds, the door's open, the blinds are open, but he's laying like in a prone position, like he's laying down, looking out. Anyways, I made eye contact with him, and when he makes eye contact with me, he has the rose flower look on his face, like, oh fuck. So I see him scoot back and he breaks it and he's out. So I grab my key and we walk out, go back to the spot, and I'm kind of like, let's see where he shoot.
Okay. So at this point, he's back at his apartment, correct? Officer Izagide? Did you hear him say that? That he went back to his apartment? Okay. And this is the terminology that you said, that you used, or that Detective Henning claimed. Okay. So he never used the term muffled popping, correct? Did you? That's how you described it, as a muffled popping? Did he observe impacts in the water which were consistent with bullets hitting the water in combination with the muffled popping sound that he heard? Did he tell you, or did he use the words that it was consistent with bullets? That the sounds that he heard were consistent with bullets. He'll use those terms. Okay. He said first he thought there was a bird diving into the water, right? That was the first time, correct? And the second time he thought his son was splashing, right? Okay. But let's wait and see where he says that it was consistent with bullets hitting the wall.
And that's when I got the courtesy call that apartment 303 was being shot up, and then it just, it sounds stupid, but I was like, oh fuck, this is a shot. I mean, maybe not just that, you can see yes, because I could hear it digging, but it echoed so much, like I couldn't pinpoint what it was. It wasn't until he started racking the gun or whatever he was doing, and I saw him that it stopped. And that's when my take off.
Do you know when that call came in at the garage? Was it before or after?
The one in the garage, when he was walking around like that? Yeah. So that was supposed to be later in the evening by the officer.
Okay.
So the only call that I had gotten was, I think it was at 8. They were.
Was it 8:25 one?
8:10. At 8:10 was when the resident and 303 called.
Okay.
Or I'm sorry. At 8:10 was when the courtesy officer was on. I don't know what time he called it. I couldn't remember before that. So he called the call center and the call center gets in touch with me.
Okay.
So it was right before 8:10 and all that happened. So right around the time where.
Yeah.
He said that, I don't know, the officer said that the call where they got the gun in the garage was sometime later in the evening. I'm assuming they're already on scene, but I don't know.
Okay, anything else?
Like I said, I've never seen him, I have no idea who he is.
Okay.
I mean, my cannot really. There's no way there.
All right, if you could pause just one moment, please.
Sure.
Francisco Galza Martinez, if you'll come forward.
The attorney just stepped out.
Oh, I'm just gonna give him a reset. Can I have a reset date for 30 days for PTD, please?
January 23rd, Judge?
All right, thank you. Oh,
Hi, Judge.
just stand there, over to the side. They're gonna give you a reset form. Thank you for dressing appropriately for court. All right, they'll give you a reset and make sure you put your email address on that. All right, defense, you can continue.
So I'm just gonna finish the video if I could, Your Honor.
Yes.
Let's just go through the affidavit, okay? So you now heard the whole video. When did he say that it was consistent with bullets hitting the water? He didn't say that? Okay, but you just testified that he said that later in the interview. But he did not, and you only spoke to him one time, correct? Okay, and that was captured on this body cam, right? Okay. So he never said that it was consistent with bullets hitting the water. He never said that he could tell that the muffled popping was coming from an elevated position. He never said that, right? He said he made a clapping sound, correct? And he said he couldn't tell where it was coming from, right? So that's also false, right? Yes?
Yes.
Victim 1 reported to remove victim 2 from the pool while seeking a position of cover while believing he was being shot at by the suspect. He never said that. He did not say that, correct? Right? And he only realized he was being shot at after he got to the apartment, correct? After he got to the apartment and when he got the call for the broken window. He says that only after he got to the apartment, he says this motherfucker was shooting him. Something like that.
That's asked and answered. She stated, what she believes he said.
All right, that'll be sustained. Any other questions?
Yes, Your Honor. So at what point did you show him a photographic lineup?
While we were outside investigating.
Was that, so it was not a photographic lineup? It was a single photo? And was your body cam on for that? It was not? Okay, so when you told Detective Henning that it was a photographic lineup, that was a lie.
The defendant was identified
By a single photo. And he decided to swear on his own that it was a photographic lineup. But there's a difference between a photographic lineup and a single photo, correct? Yes?
Yes.
Okay, what's the difference? A series of photos. Okay. And you did not have your body cam on, but you previously testified that you only spoke to him one time. Testified to that today. But you really talked to him twice.
While you're out there and something actually happens, from the photo to and to come by identity.
It is not captured on this body cam, correct? Okay, is it captured on any body cam? Your body cam was off. And how did he identify the single photograph?
All right, so here's my question. Is his identification of a single photograph, is this a part of the motion, or are we now proceeding into territory that's best for cross-examination in front of a jury if I rule against your motion?
So I think that I think that, so I'm establishing that this is a deliberate falsehood. Is what I'm doing. And I think that we've done it. So I'll move on. And did you tell Detective Henning that it was a single photo and not a photographic lineup? Okay. But as a police officer, you understand the difference. As a detective, you understand the difference between a photographic lineup and a single photograph.
Objection, Austin, answer.
Sustained.
And do you have that photograph that you showed? But did you, how did you preserve it?
All right, so is this a part of this hearing or is this something for cross-examination?
I think it is a part of it. Well, so it doesn't have to be a part of this hearing. I do need to know this though.
All right, so this is specifically for this hearing. You all have both said that you all have received all of the discovery. So it appears from the court, and if I'm wrong, correct me, that the question that you're now asking is not related to this motion. It's something for cross-examination. Am I incorrect in that?
That's correct, Your Honor.
All right.
Your Honor.
Well, just one second. Any further questions?
I'll pass the witness, Your Honor.
All right, state.
Detective Porter, I'm gonna ask you to speak up because I'm kind of having a hard time hearing you. The court order has to down response. Okay. However, so you were the detective that was assigned to SAPD 22-11-836, correct? And so you made contact with Jesse on June 4th, 2022, is that correct? And you conducted an interview with him on that day?
Yes.
Okay, and we watched State's Exhibit B, correct?
Yes.
And you previously reviewed that, correct?
Correct.
Okay, and so in watching that, Jesse Izaguren did state that he believed ultimately and came to the conclusion and suspected that somebody was discharging a gun or pellet gun, correct? And also in State Exhibit number B, Jesse Izaguren stated that he observed the resident at apartment 251 holding something, although he could not tell what it was, correct? And he also stated that he heard which he stated was consistent with the racking of a firearm in his backpack. And so regarding the elevated position, he identified the suspect apartment as apartment number 251, correct? And that apartment was located on the second floor, correct? So that would be consistent with being an elevated position, correct?
Yes.
Okay. And regarding the muffled popping, although Jesse Izaguren did not explicitly state that, he did state that he heard. Correct? Yeah. Okay, and how would you characterize that noise? Okay, and is it typical to put, I guess, noises like that in an affidavit?
Describe the noise that's made.
But are you able, how would you characterize that popping noise? How did you characterize it? The noise that Jesse Izaguren.
The noise more.
But when that pop, 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 when you repeat that.
It's been asked and answered, Your Honor.
All right, that'll be sustained.
And then the witness also stated in his interview with you that he did hear multiple splashes, correct, in the water. And he characterized them as a pop and clapping sound, correct? And he also further stated that while the offense was ongoing, he heard a window shatter, correct? He also observed that he also stated that he observed the silhouette of a person laying halfway out on the balcony of apartment 251, correct? And that person was laying in prone position, correct? And is it typical for detectives that are working on an ongoing investigation to contact the sergeant to get a search warrant? Okay, and typically you just relay that information over the phone, is that correct? Okay. And I guess when you were relaying the information, did you intentionally misstate or make a false representation to Detective Henning when you were relaying the information that was told to you by Jessica?
Any
So.
further questions?
Yes, Your Honor. So your sequence of events here. You speak to the complainant with your body cam on, correct? You turn your body cam off. You guys go outside. You show one picture to him. Okay, so when do you show him the single picture?
Object as to outside of the scope of the motion.
Sustain.
So it's not, Your Honor, because I'm trying to determine whether or not, what is truthful.
All right, the objection is sustained.
You then turn your body cam off, correct? Okay, and at some point, you show the one picture, correct?
Object to outside of the scope of the motion.
And then.
That'll be overruled.
And then after that, you keep your body cam off and have a conversation with Detective Henning, correct? And when you were, and this search warrant, this was before any arrest warrant, correct? The search warrant was the first sworn affidavit. Okay. And you thought that and your description of the offense was a terroristic threat, correct? Well, so where did Detective Henning get the terroristic threat? Why would he swear that it was consistent with a terroristic threat?
Objection, speculation.
Sustained.
You did not tell Detective Henning that this was a terroristic threat, correct? Nothing further, Your Honor.
All right.
Nothing further.
All right, you may be excused from this hearing. All right, I'll let you all have a chance to formulate your thoughts if you need a chance to formulate your thoughts. And then I will hear arguments for both sides. Do you all need time to gather your thoughts?
I'm ready, Your Honor.
All right, proceed.
So, Your Honor, we've alleged, let's just go through the affidavit. We
Oh, you
allege.
can remain seated. It makes it easier for the court reporter to hear.
Thank you, Your Honor. So we've alleged deliberate falsehoods, and that's exactly what we have here, Your Honor. They get almost everything. It's one thing to be wrong, but another thing to be consistently wrong, prejudicing the defendant. And here, everything that they say is not only wrong.
Specifically, what is your falsehood that you're alleging?
Okay, so the bullets striking the water, consistent with bullets striking the water, that's not accurate. It's not. There's nothing in the complainant's statement that says that it's bullets striking the water.
All right, and your next falsehood?
A muffled popping sound coming from an elevated position. Okay, so he says that he's seeing this instantaneously, according to the affidavit. That's not what the complaining witness says. It was only after they were out of the pool that he sees the silhouette, and only after he was inside his own apartment and he gets the call about the shattered window that he realizes that somebody may have been firing the weapon while he was in the pool.
All right, and next?
So then, additionally, Your Honor, that he was outside the pool while his son was inside the pool, that's a falsehood. The time is a minor falsehood. I don't think that removes the probable cause, but I think it begins to try to determine why there are so many mistakes in this affidavit. Additionally, Your Honor, victim 1 reported to remove victim 2 from the pool while seeking a position of cover while believing that he was being shot at by the suspect. That is not what he said. He did not say that at all. That was completely made up either by Detective Henning or by Detective Rodriguez. Victim 1 reported that he observed the suspect laying in a prone position on the rear balcony, partially inside the apartment, partially outside, while pointing a rifle towards the pool area. It's not that. That is not what he said. Victim 1 reported that he observed suspect 1 stand, completely enter the apartment while still holding the rifle. Again, that isn't what he said. And victim 1 described suspect 1 and identified suspect 1, and he specifically says, "I don't know who it was," in the statement. It's only until, and frankly, Your Honor, the photographic lineup, and it's not a photographic lineup, it's a single photograph. There's literally nothing in this affidavit that is true. And if you excise all the stuff that is false, there's nothing left. So this is extremely problematic. So we have cleared all of our hurdles, and the fruits of this search warrant cannot be presented to this jury.
All right, state.
Yes, Your Honor. So regarding the warrant, Detective Rodriguez testified on direct with Mr. Locke that that's how she would characterize the pop, 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 pop language that was used by Jesse Ezekiel on the date of it. Regarding the time, I mean, the witness did state it was at around 7 p.m., 7:15 at around that time. Regarding the bullet hitting the water, I mean, that is a conclusion that could be made by an investigator and the course of their investigation. Regarding the victim saying that he believed that he was being shot at by the suspect, on State's Exhibit B, he does state that he did remove his son and place him behind a pillar so that he could locate the location of the threat that was being posed to him and his son in the pool. And so I don't believe that defense has met their burden of, proving any deliberate falsehood on the part of the witnesses. And the remedy would be for the court to excise the statements that the court believes are untrue, and then, look at the warrant at State's Exhibit A and determine whether the remaining content is sufficient for the warrant to issue. And so I think even if the court did, agree with the defense's position, the parts that are still true are that victim number 1 and number 2 were in the pool. He heard the rocking of the gun. He heard, the splashing of the water, saw the water coming up. He observed he observed an individual in the defendant's apartment 251, laying in the prone position. He heard the rocking of the gun. He saw that individual enter back into the apartment, accompanied with the defendant's own, statement that he did own an airsoft gun. And the witness did also state that he believed at the time that he was being shot at, and this was before he went back up to the apartment. He believed that somebody was discharging a firearm or pellet gun. That is the witness's own words. And so it's the state's position that, the motion.
All right, any final
Yes, Your Honor.
argument?
So, and I think that the state is asking you to abuse your discretion. I think it's
I'm sorry, to do what?
to abuse your discretion. And I'm going to tell you why. It is not the purpose of a Franks hearing to excise the falsehoods and then put in what they should have put in. That is not a correct mechanism for a Franks hearing. And that's what
But my understanding that is, she is asking that if the court were to find that there was an incorrect statement or a falsehood in the affidavit, she is asking the court to not replace it with something, but to excise it from the affidavit.
And that's what the court should do. And so just so.
So that the record can be clear,
Yes,
the state is not asking the court to add any information to the affidavit. The state, and correct me if I'm wrong, the state is saying that if there is something in the affidavit that I find was a misstatement or was untruthful, she is asking that I remove that and review the affidavit with that removal and see if it is still sufficient for the warrant. Is that correct? All right, you may continue.
and as long as the court sees that as its function, I think that is accurate. So, but I also think that the problem here is that the search warrant, there are two problems. Had the affidavit reflected what Izaguirre told the officer, the search warrant wouldn't have been granted, number one. Number two, they wouldn't have been able to pinpoint it to the suspect because Izaguirre hadn't identified him and didn't know who he was. And in this photographic lineup, there is a method of identifying him that is completely false. And that Rodriguez admits is completely false. And so how can you, in a non-deliberate way, confuse a single photo, if you're a detective, a single photo for a photographic lineup? How can that happen?
All right, any further argument, counsel?
So once it's excised, Your Honor, there's not probable cause. So the fruits of the search should be suppressed.
All right, thank you. What I'll do is I'll review State's Exhibit A, and then I'll give you my ruling shortly.
Judge, I have gathered it's.
All right, thank you. All right, you all may be excused.
Thank you, Your Honor.
Hi, Judge, do I need an interpreter for Edgar Aguilar for
Aguilar,
announcement?
what
or
is
it-
happening with Edgar Aguilar?
Well, it was a discovery conference.
Mhm. Okay. Okay, so for trial? All right, so what I'll do is I'll recall it back so that the coordinator can look at our schedule and see where we fall on trial. So, thank you.
So what time should we be back, Your Honor?
If you all will be back by 1:45, I know the jury is supposed to be here at 1:30. But if you all can be back by 1:45. All right, so are you available to come back on January 13th for a trial setting? All right, Lance, on Edgar Aguilar.
Hold on.
Oh, just a second. Yeah,
Calendar 4:37.
okay. I can have it called before then, if you want to come back on January 9th.
Let's do that.
All right, Lance, on Edgar Aguilar, if you can recall that back for January 9th. And it'll just be for a jury trial setting.
Perfect. So that is not the setting for the.
No.
Okay.
Because we have murders and capital murder set, and I don't have those dates before
Right.
me at the moment.
Okay, perfect. Thank you, Joe.
All right,
I'll
thank
just
you.
meet with you.
Just one moment. Let me put this in the system.
No, all right, let me get that file up to the judge.
Yes.
I have
All right, everybody's whispering, either something's happening with my hair. Did you ask them to pull it?
Sorry, Judge, can't pull it. Mr. Moreno. Thanks. My apologies.
Okay.
Yes, ma'am. It's gonna be a week, like, week from now.
Yes. Where's he? Jesse Marino?
You got Javier Herrera up there. The other guy. I'm gonna talk to him, we were already.
All right, Lance. On Jesse Marino, that's going to be recalled for tomorrow for disposition.
Okay.
All right, once you sign the reset form, you'll be excused.
I'll bring it to you. Ready by the union?
No.
Yeah. There we go. My lips is not a good job, so I gotta get to 70. With the hard copy. Not mine.
All right, Rogelio Valero.
He's not out here right now. It's got an MTR in a new case. Actually conferred, I got an offer that includes both. I was gonna ask the board if I could come back this afternoon. So I'm just trying to get to CLE right now.
Sure.
But I understand.
Or if you want to recall it for tomorrow.
I understand you guys. So if I can come back tomorrow. Okay.
She's looking at me. Are you able to,
Or next week. So the state of the case judge, they're still not fighting on camera live reports yet.
okay.
So it's.
Bashan is giving me the look. All right. We cannot call it back next week. And what is his new case? Who is the prosecutor on Rogelio Valero?
Jason was looking at it. Judge.
Okay.
It's 1 to 4. And right now there's an off on 4, but no labs or.
Okay. So on this case, he says that there's no labs on the 1 to 4.
Correct, yeah, I mean, I believe there's some other allegations. But, I just gave an offer.
Okay.
Oh, that's fine.
Okay, you're at CLE.
I'm ready on both of mine.
Okay, so then you're still in your CLE, right?
It's just over the lunch hour.
All right, if you want to come back this afternoon, if y'all are gonna, all right, see.
Excuse me.
All right, Lance, if you can recall this tomorrow. It's Rogelio. All right, we'll see you then. Thank you.
Thank you, Judge.
You're welcome. Thank you.
Make sure, well.
You don't want
Thank you, Judge.
You're welcome.
What are we gonna be doing on which one?
Yes.
On Herrera, we're gonna ask for another reset to
And on Tran, it's a recommendation of deferred, so hopefully that's gonna be that.
I'll double check though. Makai Williams. Oh, I have it. All right, thank you. Hello.
Yes, Your Honor.
Hello.
Well, conferred with the state, they have made an offer, I've voted on the offer with my client. I still need to go over the discovery with the client as well. I've just kind of pointed these cases and they're voluminous in nature, so I need to go over that with him.
All right, we'll set it for discovery and we'll set it for discovery at the end of January. If your attorney wants you brought back sooner, we can bring you back sooner. Do you understand? Do you have any questions about anything? All right, Lance, if I gotta have a discovery on Williams for the end of January.
January 28th, Judge?
All right, January 28th.
Yes, thank you, Your Honor.
Thank you.
Make them to paper up and fly. Oops, no, PSI. And I had an announcement on a fraud case and then a PSI.
She's a little slow.
Sentencing.
All right, Jared Sanchez.
We're ready, Your Honor.
Court is calling 2024 CR 3278 State versus Jared Jesse G. Sanchez. Can I have parties announced for the record for the state? Defense,
Tony Jimenez.
are you Mr. Sanchez? Counsel, have you received all discovery? Did you review it with your client?
I did and I have.
Mr. Sanchez, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented? Court will find that the state is in compliance with discovery. Mr. Sanchez, did you review court admonishments and defendants waivers with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
You're charged with evading arrest detention vehicle. That is a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea, you're giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is. He was.
Mr. Sanchez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $2,000 fine and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it
Yes, ma'am.
and sign it in both places?
Yes, ma'am.
Did you understand by signing that you were waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
None, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
No objections.
State you may be excused. Did you review the waiver and consent to stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We would like to, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right. Are you employed?
Yes, ma'am.
What do you do?
Age 30.
All right. Do you have any children?
Yes, ma'am.
What are their ages?
She is a month. She just turned a month.
All right. All right, this is what the court will do. The court is going to sentence you to a $2,000 fine. That will be probated. 4 years deferred adjudication, regular reporting by Zoom or in person, regular UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. There's to be field visits 1 time per month for 3 months, 200 hours of community service restitution. 100 hours will be waived upon completion of parenting classes. And I'm also going to order the defensive driving course, and the remaining 100 hours will be deemed satisfied once you've completed that course. Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
No.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I call it your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. To be successful, communication is key. If you feel as though probation is not addressing issues, let the court know. You can come into court. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Jasmine.
Thank you. All right, who is here on Tuan Hung?
Same judge. Judge Mayor.
Yes.
His wife is present. She doesn't.
Okay. Okay. then. All right.
Other case.
Okay. Okay. All right, court is calling 2024 CR 007-862 State versus, how do you pronounce your name? All right, Tuan Hung. Could I have parties announced for the record for the state? Defense.
For the defense.
All right. And are you Tuan Hung?
Yes.
Right. Counsel, have you received all of the discovery? Did you review it with your client?
Yes, I have.
Court will find that the state is compliant with discovery. Mr. Hung, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Has there already been a plea?
This is just a piece.
So you know what the thing is? I didn't
You
take the
didn't
plea.
take the plea, yes. Yes.
All right,
Angelini was visiting for you at the time. He took the plea on your behalf.
all right. So then,
This
There's-
is simply a sentence.
all right, so there's been a change to the plea bargain agreement. The state is rejecting the cases that were to be taken in consideration. Do you understand that? All right. And then it wasn't written on the form. How did you plead to this offense? Guilty, not guilty, or no contest? Okay. All right, then, did both parties have a chance to review the TAP evaluation and PSI?
Yes, Your Honor, we did.
Any objection to the PSI or TAP evaluation, state?
No, judge.
Defense?
No, Judge.
All right, anything you wish to say on behalf of your client?
No, Judge, we believe he's worthy of the plea bargain. We ask you to follow it. And then we do have a couple of questions, a couple of things for you to court to consider at the appropriate time regarding just how he's going to be able to help him make sure he gets his tools and materials from the house when no one's present. And then to facilitate, part of the plea bargain is to allow him to have contact through video calls and telephone only until he completes his parenting classes. So just how we're going to facilitate that.
But other than that, no, we believe the plea bargain is set up after the state's had an adequate time to discuss everything with the complainant. And we believe it will do everything to help reunify this family and get everything back on track.
All right, was Child Protective Services involved?
They still are.
All right. All right, and then the defense presented me with a letter from his wife.
Yes.
Any objection to the court having reviewed that? All right, the court has reviewed the letter. This is what the court will do. Count 1 and count 2. My assumption is that those were to run concurrently.
Yes, Judge.
All right, that will run concurrently. This is what the court will order. 4 years deferred adjudication. Proof of employment within 30 days. No employment as a home health care provider or with minors. CPS compliance. The court is going to order parenting classes. And probation, if CPS, which they should have ordered parenting classes, if they've ordered those, then those will be acceptable to the court. Anger management. Regular reporting by Zoom or in person. Regular random UAs. No in-person contact with the following. Jaden, Jayden. Justin. Hung, Hoang. And Wen, Huyen, View, VU. Field visits 1 time per month for 6 months. Probation, is there anything else?
Judge, can you give me the name for the second name, please?
The second name, Justin. Oh, third name is Huyen. The last name is V as in Victor, U.
And Jaden and Justin are 2 different people?
Yes.
Nothing else, Judge.
Judge, can we revisit the no in-person contact once he completes the parenting and the anger management classes?
Yes.
Thank you.
All right, and do a MIC evaluation, and that can be done out of custody.
Yes, Judge.
Is there anything else he needs with regards to mental health?
No, Judge.
All right, is there anything else that you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you.
Thank you.
You're welcome. Yes. William Camarillo.
Oh, my bad.
William Camarillo. All right. And Rashawn, there's no application on this. Court is calling 2023 CR 7819, State of Texas versus William Camarillo. Could I have parties announced for the record for the state?
Jason Garrett.
Matt Stolhansky for Mr. Camarillo.
And are you Mr. Camarillo? Counsel, you received all discovery. Did you review it with your client?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it? Court will find that the state is in compliance with discovery. And state, are you proceeding on the indictment as presented? And defense, you're waiving the reading of the indictment?
Yes, Your Honor.
Mr. Camarillo, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand your charge of possession of a controlled substance, penalty group 1 less than 1 gram, That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights? And did you intend to give up those rights and enter into a plea in this court? And did you understand all the rights I've just explained to you? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Mr. Camarillo, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishments be assessed to 15 months in the Bexar County Jail under 1244. Did you understand that to be the plea? Defense, is that the plea?
That's the plea, Your Honor.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Your Honor, I've reviewed my client. We have no objection.
State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
Mr. Camarillo has been in custody since October 4th of last year. He was in Nueces County, Hayes County, and Travis State Prison. And he was released from there to here. So he's got over 15 months in.
All right, the court, as previously stated, is finding you guilty. The court will sentence you to 15 months in the Bexar County Jail under 1244, give you credit for any time served. Court will show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it in all the appropriate places? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? We can go off the record. What you've learned from being in prison and being in jail. I know you probably say you don't want to go back there again. You need to get a handle on this drug problem. When you're released, if you can't find a place to go, if you come back here and I'm here, I'll find a place for you. All right, good luck to you. Sorry, I need that. All right, Eric Padilla. All right, where are we on discovery?
Judge, I haven't received all the discovery yet, just for the court's information. I was appointed on one of the ag robbery cases. There was another attorney appointed to the other case. I'm asking the court if you would be able just to appoint me on both so that we could
All right, if
move
you'll,
forward.
yes, if you'll speak with Lance about that, I don't think there'll be any problem. And Lance, could we put this for the end of January for discovery? January 30th.
sure.
We'll come back on discovery. If your attorney wants you brought back sooner, he'll let us know. All right, thank you.
I appreciate it.
You're welcome. All right, who's here on Javier Herrera?
Javier, stand up.
Who's the attorney for?
I am.
Oh,
And is Ray Saldana here somewhere?
right behind you.
That wasn't a height joke.
Ah. Santa is watching.
I blew that like January 2nd.
All right, so what I'll do, my understanding, y'all wish to have a jury trial?
We are wanting a jury trial. There's still some outstanding discovery.
So, yes, I just uploaded the notes from that conversation today, so I think they will be discussed at the Wednesday today. There's also another witness that I would like to talk to, which is the on-trial witness, and I'm not had a chance yet, I can get at least a week or two. Or I can ask for it to be separate file.
All right, Lance, can you set this for the second full week in January? That will be the last discovery. After that, it's going to be a jury trial setting. All right,
Yes, please.
thanks.
Thank you.
I'm waiting.
The 14th.
Okay.
16th.
14th or 16th. All right, 14th. Thank you. All right, who's here on Jennifer Rodriguez? Court is calling 2024 CR 011008 State versus Jennifer Lee Rodriguez. And there are no applications?
No, Judge, just for the record, she's slow.
Oh, no problem. All right, could I have the parties announced for the record for the state? Defense?
Bridget Garza for defense.
And are you Jennifer Lee Rodriguez? Counsel, have you received all discovery?
Yes.
Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Ms. Rodriguez, did you review the indictment? Those are telling you what your charges are. Did you review that with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're waiting count one, proceeding on count two. And Judge, there's, I believe that the indictment on count two was incorrect. And we are asking to, verbally amend it.
All right, what are you requesting to amend it to?
The last portion, Judge says, is of an amount of 1 gram. We're asking to add the, at the end of that, or less.
Any objection?
We have no objection, Your Honor.
All right, do you understand that they are asking that count two, there be a change to it? Did you understand that? All right, so they want to add or less those words. Did you understand that? All right, so that's a big change. Knowing that that's a big change, you have a right to say, you know what? I don't want to do this today. I want to wait to give my attorney a chance to review some things. Your attorney will have 10 days to do that. Do you want to go forward with that change, or do you want your attorney to have time to look over things? All right, thank you. All right, did you review your rights with your attorney?
Yes, ma'am.
All right, then you're charged with possession of a controlled substance, penalty group 1, 1 gram or less. It's a state jail felony. State jail felonies, the range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Do you understand?
Yes, ma'am.
All right. You have an agreement with the state. I don't have to follow that agreement. I will tell you from reviewing everything, I most likely will follow the agreement. But if I decided not to follow the agreement, then you would have a right to withdraw your plea. You understand? All right. Did you understand you have a right to go to jury trial? All right. Because you're entering this plea, you're telling the court you don't want to go to jury trial. Do you understand? Do you want the court to go forward with this plea? Yes, that's what you want? All right. You don't have to testify. And by going forward with this plea, it also means that your attorney is not going to get a chance to question any witnesses. You understand? Counsel, has your client been able to provide you with any defenses? Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes.
Do you believe she's currently competent and was legally sane at the time of the offense? Ms. Rodriguez, has anyone forced you to go forward with this plea? Anybody promise you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain with your attorney? Did you understand it? All right, according to the plea, your punishment is going to be 95 days in the Bexar County Jail under 1244. The state will take in consideration 2024 CR 011002 and County Court Cause number 719551. Did you understand that to be the plea? Defense is at the plea?
It is, Your Honor.
State is at the plea? And is this going to result in a judgment satisfied?
It is.
All right. Did you review the waiver of appeal paragraph with your attorney and sign it?
Yes, ma'am.
All right, by signing that, you're giving up your right to appeal. You're giving up the right to say, hey, I changed my mind, or I don't like the way that was done. Do you understand?
Yes, ma'am.
The only exception to that is if your attorney has filed some motions for me to hear, you understand, and rule upon. Counsel, have there been any such motions?
There has not.
Then to the offense as charged in count 2, how do you plea? Guilty? Okay. State any evidence?
Yes, Your Honor.
No objections, Your Honor.
All right. Did you review those documents with your attorney? Did you understand them? All right. Again, you know you can go to jury trial if you want to. By entering this plea, you're telling the court you don't want a jury trial. Is that still true? All right. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Okay.
All right, anything you wish to say on behalf of your client?
Judge, we're just asking the state to follow the recommendation.
Asking the court.
Sorry.
That's okay. Excuse me, can you sign that? All right, then the court will find you guilty. The court is going to sentence you to 95 days in the Bexar County Jail under 1244. Take in consideration 2024 CR 011002 and County Court Cause number 719551. The court will show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. You understand? We can go off the record. When you're released, if you have an issue with finding a place to stay or helping you with any drug issues, you can always come back to this court, okay? All right, good luck to you. I'm only doing these last 2 cases. Everybody else is gonna have to come back this afternoon or on a different day. Thank you. Byron AG.
Thank you.
And Cindy, we're gonna take our lunch break and we'll have to do. Court is calling 2024 CR 007572. State off the record. The last case I have is Eduardo Ramon. Right. Could I have parties announced for the record for the state? Defense?
Tony Jimenez.
And are you Mr. AG? Is it AG or age? Age? All right. Counsel, have you received all discovery?
We have.
Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. AG, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented? All right. Mr. Ag, did you review the court admonishments and defendant's waivers with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Your Honor. What?
Mr. H, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 5 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon, and no applications. Did you understand that to be the plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, no.
Outside the agreement, the state is requesting no contact with the complainant. Did you understand that's a recommendation from the state and the court does not have to follow those recommendations? Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
No objections.
All right, did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing safe exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are.
All right, anything you wish to say on behalf of your client?
Very briefly, Judge, my client has a history of mental health issues, diagnosis, treatment. He was homeless. We would ask the court, if the court does follow the recommendation of the 5-year sentence, that it make a referral to the therapeutic community.
All right. The court will find you guilty. There's an affirmative finding of family violence. There's to be no contact with Pablo Juarez, and there's to be no contact with uh 7616 Calabria Road. San Antonio, Texas, 78251. And no contact with Braulio, Braulio, Cruz, Pacheco. And the court will sentence you to 4 years in the prison, give you credit for any time served. And the court will request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. Your mental health issues, your drug issues do not give you leave to violate the law. I understand that sometimes when you're homeless, you have to make sure that people know that you're physically strong and they can't do certain things to you, but you're not allowed to do that. You understand? All right, good luck to you. You're
Thank you,
welcome.
Judge.
Thank you.
Excuse.
Who's here on Eduardo Ramon?
I am Judge.
Are you all ready to proceed?
We are Judge.
Court is calling 2023 CR 4449, State of Texas versus Eduardo Ramon. Could I have parties announced for the record for the state? Defense?
Kelly Piddle.
Are you Mr. Ramon Jr.?
Yes, ma'am.
Did you review the motion to revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Eduardo Ramon Jr. who's placed on community supervision in 2023 CR 4449 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on October 5th, 2023 for a period of 6 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor, I had a petition for County, Texas, the defendant Eduardo Ramon Jr. Within their failed to report to supervision officer as directed for the months of January and February 2024 in violation of petition.
How do you plead to that? True or not true? Any objections to the state waivers?
No.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty? Well, you're already been determined to be guilty, but the court could find it true and sentence you up to 10 years in prison and up to a $500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor.
And what are you requesting?
I the motion on probation. Include a jail sanction of 10 days, also DDOP, and then also monthly year analysis and sober support meetings per the TAP recommendation.
All right. Are you asking the court to follow that agreement?
Yes, Judge.
Any objection to the court reviewing the court summary?
No. Judge, he has a County Court 13 ABI family case that he was arrested for and has an offense date prior to him being placed on probation in this case.
Okay.
And he had a warrant for that case. I think that had a large factor in why he was not reporting. I've alerted his counsel on that case that his MTR will be resolved today.
All
to
right.
then go to court.
So I don't have the court summary. Ms. Abrams, on Vermont, what is your,
Here you go.
thank you.
Email this morning.
Okay.
According to the summary, probation recommendation is a jail sanction, dual diagnosis outpatient program, monthly year analysis, and sober support meetings.
The TAP was conducted in jail, Judge.
Okay, so the tap was recently done?
Correct, Judge.
All right, Mr. Ramon, you know yourself better than I do, better than your counsel does, or anybody does. So you have to ask yourself truthfully, are you going to complete this probation or not?
Yes, ma'am.
So here's the thing. I can revoke you today, and if I revoked you today, on this case, I would sentence you to 4 years in the prison. Or I can continue you and follow the recommendation of probation.
Yes, ma'am.
Do you want to discuss that?
No, recommendation. It's quicker than that.
So you want to continue with probation?
Yes, ma'am.
All right, the court will deny the motion. Alter and amend conditions to include the following. It'll be dual diagnosis, outpatient treatment with probation, monthly UAs. And there's gonna be 120 sober meetings in 120 days. And you're gonna need to get a sponsor. So when you go to those meetings, start thinking about who you would want to be your sponsor. So that it can be somebody you can call up if you think about, hey, I feel like using, you understand? And is there anything else probation?
I'm sorry, are you going along with the no sanction or no?
No. Yeah. I mean, how long has he been in jail?
It's been in jail 20 days already, so.
Yeah. So I'm not gonna do a jail sanction. If I were to do a jail sanction and give you credit for the time that you've already been in jail, if you were revoked, you know what ended up happening? You would not be entitled to those days because they will have already been used for your jail sanction. You understand?
Yes, ma'am.
All right, is there anything else you need from the court to be successful?
No, ma'am.
All right, good luck to you.
Thank you. Thank you, Judge.
You're welcome.
Done.
Jason, could you give that to Rashawn? And we're taking our lunch break and we'll be back at 2.
Try, right?
Yes.